Hi, constructive discussion with the Ambassador Yuval Rotem, the former Director General of the Israel Ministry of Foreign Affairs, related to the topic of Israel and the world. A discussion that allowed us to have an overview and a better understanding on the challenges and opportunities facing Israel in the Middle East and beyond. I will get back now to speak and continue speaking about the repertoire of the practice of the Security Council related to the 23rd supplement of 2020, the topic related to climate crisis and its impact on international peace and security. So we're going to go to the primary responsibility of the Security Council for the maintenance of international peace and security under Article 24. In order to ensure prompt and effective action by the United Nations, its members confer on the Security Council primary responsibility for the maintenance of international peace and security and agree that in carrying out its duties, this responsibility, the Security Council acts on their behalf. In discharging these duties, the Security Council shall act in accordance with the purposes and principles of the United Nations. The specific powers granted to the Security Council for the discharge of these duties are laid down in chapters 6, 7, 8, and 12. The Security Council shall submit annual and, when necessary, special reports to the General Assembly for its consideration. Section 1 covers the practice of the Security Council concerning its primary responsibility for the maintenance of international peace and security under Article 24 of the Charter and is divided into two subsections. Subsection A deals with decisions adopted in 2020 that refer to the primary responsibility of the Council pursuant to Article 24. Subsection B examines references to that article that is made in discussions held during Council meetings and open video conferences. During the period under review, the Council did not adopt any decision explicitly referring to Article 24. This charter provision was, however, directly invoked in several instances during meetings of the Council as well as in the context of open video conferences, notably in relation with the item entitled Maintenance of International Peace and Security and during the annual discussion on its working methods in connection with the item entitled Implementation of the note by the President of the Security Council S/2017/507. Explicit references to Article 24 were also made in 5 communications of the Council in 2020. In a letter from the permanent representatives of Kuwait and St. Vincent and the Grenadines, Article 24 was explicitly referenced twice in connection with discussions on the working methods of the Council held during the informal retreat organized from the 17th to the 19th of January 2020 in Kingstown. In addition, a letter from the permanent representatives of Estonia and St. Vincent and the Grenadines, 3 explicit references to Article 23 were made in the concept notes for the open video conference held in connection with the item entitled Implementation of the Note by the President of the Security Council S/2017/507 on the theme Ensuring Transparency, Efficiency and Effectiveness in the Work of the Security Council that was held on May the 15th, 2020. In a subsequent analytical summary of that video conference contained in the letter dated on July the 8th, 2020 from the permanent representative of St. Vincent and the Grenadines, 4 explicit references to Article 24 were also made. In addition, in a letter dated on August 3rd, 2020, the permanent representative of Pakistan submitted in an annex a legal appraisal of the Jammu and Kashmir dispute in which reference was made to the International Court of Justice in its advisory opinion on the Namibia case, containing an explicit reference to Article 24. Furthermore, in a letter containing a concept note for the open video conferences held on December 18, 2020, in connection with the item entitled The Promotion and Strengthening of the Rule of Law in the Maintenance of International Peace and Security and the theme of strengthening the cooperation between the Security Council and the International Court of Justice, the permanent representative of South Africa made 1 explicit reference to Article 24. So the decisions referring to Article 24 could be summarized as such. During the period under the review, the Security Council did not refer explicitly to Article 24 in its decisions. Instead, in 7 resolutions and 5 presidential statements, the Council referred to its primary responsibility for the maintenance of international peace and security while taking a broad range of actions consistent with past practice. Implicit references to Article 24 were mainly featured in the preambular paragraphs of resolutions and initial paragraphs of presidential statements, predominantly in connection with thematic items on the agenda of the Council. In 2020, the Council implicitly invoked Article 24 in 7 resolution in which it reaffirmed, recalled, bore in mind, or indicated that it was mindful of its primary responsibility for the maintenance of international peace and security while taking a variety of action. 2 of these resolutions were adopted in connection with Libya under the items entitled The Situation in Libya and Maintenance of International Peace and Security, in which the Council acted explicitly under Chapter 7. The other 5 resolutions concern thematic items relating to different issues ranging from the safety and security of peacekeepers, women in peacekeeping and security sector reform, to the implication of COVID-19 pandemic for the maintenance of international peace and security and youth peace and security. Now, if we move to the presidential statements while analyzing Article 24, in the year under the review, the Council adopted 5 presidential statements containing implicit references to Article 24 in which reaffirmed, reiterated, or recalled its primary responsibility for the maintenance of international peace and security. The 5 presidential statements concerned items related to upholding the United Nations Charter, integrating child protection into peace processes, protecting civilians from conflicts-induced hunger, addressing attacks against schools and the grave violation of children's rights, and cooperation between the United Nations and regional and sub-regional organizations. So, among the details that we can analyze here regarding decisions in 2020 implicitly referring to Article 24 of the Charter, we can look at the decisions such as the S/PRST/2020/1 of January the 9th, 2020 on the 3rd paragraph related to maintenance of international peace and security. The sub-item is upholding the United Nations Charter. Then there is the S/PRST/2020/3 on February the 12th, 2020 on the first paragraph related to children and armed conflict. The sub-item here is integrated child protection into peace process. Then there is the resolution 2518 of 2020 on March the 30th, 2020, the first preambular paragraph under United Nations peacekeeping operations, the sub-item related to safety and security of peacekeepers. Following that, S/PRST/2020/6 dated April 29, 2020, and the second paragraph on protection of civilians in armed conflict, the sub-item related here to protecting civilians from conflict-induced hunger. Then there is the resolution 2526 of 2020 passed on June the 5th, 2020, fourth preambular paragraph related to the situation in Libya. Other items could be also mentioned in this matter, but I will move to discussion relating to Article 24. During the review period, Article 24 was indeed invoked both explicitly and implicitly at numerous meetings of the Council, as well as in statements delivered or submitted in the context of open video conferences. Speakers made 3 explicit references to Article 24 at 2 meetings held in connection with the item entitled Maintenance of International Peace and Security. In addition, Article 24 was expressly invoked in 12 occasions in statements delivered and submitted in writing in the context of an open video conference held in connection with the item entitled Implementation of the Note by the President of the Security Council UNDO S/2017/507. The following case studies illustrate the nature of some of the issues discussed in 2020 with regard to the interpretation of the primary responsibility of the Council for the maintenance of international peace and security pursuant to Article 24 of the Charter. The cases captures basically discussions held in connection with items related to the maintenance of international peace and security. Cases 1, 3, 4, And 5. Implementation of the notes by the President of the Security Council S/2017/507 Case 2 and Peace Building and Sustaining Peace Case 6. If we speak about Case 1 related to maintenance of international peace and security, we have to refer to the 8699th meeting held on January the 9th, 2020 at the initiative of Vietnam, which held the presidency for the month. The Security Council held a high-level open debate under the item entitled Maintenance of International Peace and Security in connection with the sub-item upholding the United Nations Charter. At the meeting, the Council adopted the presidential statement on the occasion of the 75th anniversary of the United Nations, reaffirming its primary responsibility for the maintenance of international peace and security. The Council also heard briefings by the Secretary General and the Chair of the Elders. In his intervention, the Secretary General stated the trust within and among nations was on the decline, which could be seen in the work of the United Nations, including the Council, when member states struggled or failed to find reasonable common ground, adding that the climate crisis spared no one and that international cooperation was at crossroads. The Secretary General affirmed that those elements presented a grave test to multilateralism and posed a challenge for the Council, which under the Charter had the primary responsibility for the maintenance of international peace and security. He added that at a time of global division and turmoil, the Charter remained the shared framework of international cooperation for the common good. While the Charter and its purposes and principles remained as relevant as ever, he noted that the tools had to adapt with the new realities, using them with greater determination and creativity, including by ensuring the implementation of the Council's decisions by member states pursuant to Article 25 of the Charter. During the debate, some speakers recalled and reaffirmed that the Council had the primary responsibility for the maintenance of international peace and security. The Deputy Prime Minister and Minister of Foreign Affairs of Vietnam expressed the belief that charged by the Charter with the primary responsibility for the maintenance of international peace and security, the Council had to be at the forefront in order to ensure respect for the purposes and principles of the Charter. He added the Council members had to take the lead by setting good examples themselves. The representative of the People's Republic of China affirmed that the Charter conferred upon the Council the primary responsibility for the maintenance of international peace and security, further noting that was the sacred mission of the 15 members of the Council. He asserted that Council members had to enhance mutual trust, strengthen unity, avoid the politicization of certain issues, and remain committed to diffusing conflicts and preventing war. The representative of the United Kingdom affirmed that the Council had the primary responsibility for the maintenance of international peace and security, added that others, however, including the Secretary General through Article 99, had a vital role to play. She further echoed the Secretary General reference to Article 25 and the need to uphold the decisions of the Council in that context. The Minister for Foreign Affairs and Worship of Haiti stated that the Charter made the Council an important pillar in the architecture of the organization, conferring upon the primary responsibility for the maintenance of international peace and security. The representative of Argentina observed that the collective security system gave the Council the primary responsibility for maintaining peace and security, noting it was the organ that was legitimized through the Charter for that purpose. The representative of Mexico stated that in matters involving international peace and security, states had to act in a manner consistent with the Charter and general international law. He added that when states failed in that obligation, it was even more important that the Council be up to the occasion in order to defend and enforce the Charter in strict accordance with its power and in full exercise of its responsibility. The representative of Morocco declared that the essence of the Charter was and continued to be maintenance of international peace and security, which remained the core objective of the United Nations operation. He added that the Council, which bore the primary responsibility in that area, was dedicated to serve as the guarantor of peace and security in the world. The representative of Brunei Darussalam pointed to the Council's moral and persuasive authority to demonstrate the principles and fundamentals contained in the Charter for the maintenance of international peace and security. Similarly, the representative of Turkey stated that the Council needed to fulfill its mission as the primary United Nations organ for maintaining international peace and security because the success of the Council was, in the eyes of many, indelibly linked to the credibility of the United Nations as a whole. At the meeting, some speakers observed that the Council was challenged or even undermined by several elements in discharging its responsibility for the maintenance of international peace and security. The representative of the Russian Federation opposed the use of unilateral coercive measures in the absence of corresponding Council resolutions or in addition to measures taken by the Council which undermined its role in the maintenance of international peace and security. The representative of Japan expressed deep regret that some member states failed to comply with Council decisions, asserting that the states members of the United Nations conferred on the Council primary responsibility regarding the maintenance of international peace and security, and that the Charter required that member states accept and carry out the decisions of the Council. The representative of Afghanistan shared a similar view, stating that the lack of implementation of or disregard for Council resolutions by various countries did not only deter the efforts in the fight for international peace and security, but also led to the weakening of the political mandates of the Council. The representative of Singapore noted that there was no doubt that the Council had the primary responsibility for the maintenance of international peace and security, adding that all member states, however, could and indeed had to contribute to that. In that regard, he said that when countries disrespected a decision of the Council, they undermined the credibility of the entire Council and weakened its ability to maintain international peace and security. Similarly, the representative of Rwanda stated that there was a need for all member states to uphold the Charter in the maintenance of international peace and security, and that multilateral cooperation had to be strengthened. He added that challenges such as terrorism, climate change, and transnational organized crimes would be effectively addressed if member states work together. Other speakers also acknowledged the challenges facing the Council, while at the same time pointing to the need for unity to overcome the challenges. The representative of the United States said that the Council had to acknowledge that inaction, repetition, and intransigence that created a credibility gap. She added that the Council needed to recapture its sense of unity and purpose as the wholly with the primary responsibility for maintaining international peace and security. Similarly, the representative of Albania noted the need for a more responsive and effective Council as the body in charge of maintaining international peace and security, adding that when the Council had managed to overcome its division and take united action, it has successfully achieved the Charter's purposes. The representative of Kenya, noting that the Council carried out the primary responsibility for the maintenance of international peace and security, pointed to the applications and effects of dissonance within the Council on important international peace and security questions and actions. The representative of Kuwait stressed that the success achieved by the tools provided by the Charter for the maintenance of international peace and security would depend on unity and consensus within the Council. The representative of Lebanon noted that when the Council was blocked and prevented from taking any meaningful decision, it was not fulfilling its responsibilities under the Charter, and she added that the unity of the Council was more urgent today than ever, as the multilateral system was facing many critical tests and conflicts were multiplying. Some participants focused on the ways for the Council to overcome the challenges it was faced within maintaining international peace and security. Indeed, the representative of Liechtenstein noted that the Council was now equipped with an important new tool, the ability to refer situations involving acts of aggression to International Criminal Court if applied in a meaningful way. That new tool could assist the Council in the prevention of conflicts, reinforcing its role under the Charter to maintain international peace and security. The representative of Ethiopia stated that the Council, as the primary organ entrusted by the Charter with the responsibility for the maintenance of international peace and security, had to embrace the change in global dynamics and recommit to pursuing robust political solutions through meaningful partnerships with regional and sub-regional organizations. The representative of Myanmar said that as the Council had the primary responsibility for maintaining international peace and security, the principle of objectivity, impartiality, and non-selectivity should be applied to all member states without having double standard. When I refer to member states, I mean every member state, large or small, and this in the context of carrying out the Council's mandate. The representative of Slovenia recalled that the Council had been entrusted with the primary responsibility of maintaining international peace and security. She noted that so far the Council has succeeded in so many cases, but had failed in others, adding that members of the Council discharge the responsibility on behalf of the entire United Nations membership and should therefore look beyond their national interests. The representative of Costa Rica stated that in order for the United Nations to take up the reins of the global governance, the Council had to shoulder the responsibilities incumbent upon it in the maintenance of international peace and security, bearing in mind the considerations of its action and enhancing its conflict prevention efforts. Now, regarding the case number 2 related to implementation of the note by the President of the Security Council S/2017/507, reminding that on May the 15th, 2020, at the initiative of Estonia, which held the presidency for the month jointly with the St. Vincent and the Grenadines, whose permanent representative held the chair of the informal working group on documentation and other procedural question, members of the Security Council held an open video conference on the working methods of the Council in connection with the item entitled Implementation of the Note by the President of the Security Council, reference to S/2017/507. During that video conference, Council members held briefings by the representative of St. Vincent and the Grenadines in her capacity as a chair of the informal working group on documentation and other procedural questions, as well as by the executive director of Security Council report and a professor from Columbia University in New York. The representatives of France, the People's Republic of China, the Russian Federation, the United Kingdom, and the United States delivered their remarks during the video conference, as this did the representative of Vietnam, who spoke on behalf of the 10 elected members in their written submission published as part of the record of the video conference. Representatives of non-council member states also made explicit and implicit references to Article 24, focusing therein on the responsibility of the Council to act on behalf of the wider United Nations membership in accordance with Article 24. Several speakers underlined the importance of inputs from the wider United Nations membership for the discharge of Council duties stemming from Article 24. The chair of the informal working group on documentation and other procedural questions noted that pursuant to Article 24 of the Charter, the Council acted on behalf of the members of the United Nations, adding that as such the holding of the debate demonstrated the significant value that the Council attached to the voice of the United Nations membership. Speaking on behalf of the non-permanent members, the representative of Vietnam looked forward to receiving the views and inputs from the wider memberships of the United Nations to improve the working methods of the Council so that it could better fulfill its responsibility under Article 24. Discussing the responsibility of the Council under Article 24, several participants also raised the issue of the impact of the COVID-19 pandemic, touching upon the unprecedented circumstance posed by the pandemic. The representative of St. Vincent and the Grenadines remarked that in the light of its primary responsibility for the maintenance of international peace and security, the Council could not be allowed to be paralyzed. In a similar vein, the representative of the People's Republic of China, noting that the Council bore the primary responsibility for maintaining international peace and security, stated that the international community expected the Council to play its due role and appropriately address prominent issues concerning international peace and security, adding that COVID-19 had brought unprecedented challenges to the functioning of the Council. In his written statement, the representative of Azerbaijan referred to the primary responsibility for the maintenance of international peace and security conferred on the Council. He added that the emergence of COVID-19 pandemic had triggered the need for taking additional urgent measures aimed at safeguarding the effectiveness of the Council under unprecedented and extraordinary circumstances. The representative of Liechtenstein, in his written statement, expressed the view that the Council response to COVID-19 was an opportunity to consider broader questions. Chief among these was the need to take on a perspective of peace and security that was human-centered. He added as a key lesson that addressing human security was no less important to the maintenance of international peace and security than preventing and aiding the outbreak of armed conflicts, and that both were intimately linked. He noted that the Council was certainly less prepared to deal with the fundamental dimension of security. The delegation of the United Arab Emirates noted that the world relied on the Council for the maintenance of international peace and security, even when meetings did not take place at the iconic horseshoe table. In the written statements, various non-Council members highlighted the prerogative of the Council to act on behalf of all member states of the United Nations in line with Article 24, and in this context noted the importance of transparency and efficiency in its work. The representative of Cuba submitted that in accordance with Article 24, member states of the United Nations recognized that the Council, in discharging its function, acted on their behalf, and consequently the work of the Council was the collective responsibility of all member states. She added that greater transparency in the work of the Council would thus help in fulfilling that collective responsibility. The representative of Ecuador noted in his statement that while the Council acted on behalf of all member states on the basis of Article 24, that representation also meant that it had the obligation to ensure prompt and effective action by the United Nations as set out in that same article, an obligation that had to be fulfilled without any exceptions, and according to the representative of El Salvador, improving the Council's working methods and adapting them to the evolving realities of the Council and the international context was vital to fulfilling the mandate of the United Nations Charter and to taking decisions that would ensure rapid and effective action for the maintenance of international peace and security. Explicitly referring to Article 24, the representative of Italy noted that the Council was expected to make decisions that would secure effective action on behalf of the wider United Nations membership. The Council should therefore be accountable to the wider membership, she added, especially when its inaction prevented the Council from fulfilling its responsibility to maintain international peace and security. The representative of Kuwait made a similar point, recalling that Article 24 stipulated that the Council carry out its duties on behalf of all member states, and stressing that the responsibility for ensuring that the Council was held accountable for its action and its proper functioning in line with its mandates rested with the wider membership. According to the representative of Morocco, Articles 24, 25, and 26 provided the Council with important powers and prerogatives which it could not exercise without adopting an effective and efficient approaches. The delegation of Norway on behalf of the Nordic countries recalled the fundamental principle that Article 24 enshrined the responsibility of the Council to act on behalf of the entire United Nations membership, which meant that the Council had a responsibility to undertake broad engagement and consultation with non-members, particularly the concerned states. The representative of the Philippines noted that the wider membership should be able to take part in the process in a meaningful way, which was in line with Article 24. Similarly, the representative of Poland affirmed that continuous, transparent, efficient, and agile functioning of the Council, both during ordinary and exceptional circumstances, should be ensured in line with Article 24 as well as Article 28, explicitly referring to Article 24. The representative of the Republic of Korea noted that this provision emphasized that the Council should act promptly, effectively, and on behalf of the wider membership. In this regard, he welcomed the holding of the video conference with the participation of non-Council members, believing that it was a testament to the Council's commitment to continuing to promote transparency and efficiency while holding itself accountable to the wider membership. In their written statement, non-Council members stressed the need for the Council to act preventively, effectively, and promptly as aspects inherent to its primary responsibility for the maintenance of international peace and security. The delegation of Australia submitted that to achieve its core function of maintaining international peace and security, the Council was encouraged to use all of the tools at its disposal in order to enhance its ability to prevent and not just respond to conflicts in line with the sustaining peace agenda. With regard to the Council's responsibility for the maintenance of international peace and security, the representative of Azerbaijan noted that effectiveness and accountable functioning necessitated first and foremost the implementation of the Council's decisions. He submitted that Article 25 of the Charter was clear about the obligations of member states and noted that the objective of maintaining international peace and security was hardly attainable if universally recognized fundamental values, norms, and principles were overtly disregarded, misinterpreted, or made conditional by aggressors who sought to whitewash their illegal actions. According to the delegation of Cyprus, as the organ entrusted with the maintenance of international peace and security, the Council needed to be kept informed about peace progresses and agreements brokered by the United Nations so as to be able to endorse such agreements and to play a responsible role in their implementations, which required better synergy between the Council and the Secretary General. Concerning the effectiveness of the Council, the representative of Malaysia submitted that the Council needed to do its best in closing the gap between early warning and early action. He added in this regard on the decision-making processes that the Council needed to act promptly, decisively, and in unison in maintaining international peace and security. Too often, due to the current veto system, the Council had failed in its mandates, owing to the narrow interests of some members. I will get back furthermore to speak regarding this report by focusing on the next videos on the case number 3 related to the maintenance of international peace and security following the adoption of Resolution 2532 of 2020 on July 1st, 2020. Moreover, I will try also to cover other topics related to the maintenance of international peace and security, which will be the fourth case. That was basically a focus on a meeting held on July the 24th, 2020 at the initiative of Germany, which held the presidency of the Security Council that month. Among the other things that could be mentioned always in the context of action of peace and security related to the repertoire of the practice of the Security Council, the 23rd supplement of 2020, the case of maintenance of international peace and security on a meeting that was held on September the 17th, 2020 at the initiative of Niger, which held the presidency of the Council that month. Also, the sixth case here will be related to the peace building and sustaining peace. focusing on the meeting of November the 3rd, 2020, where Security Council members convened an open video conference in connection with the item entitled Peace Building and Sustaining Peace and sub-item entitled Contemporary Drivers of Conflicts and Insecurity. Only then we can move to a second portion from the synthesis of this report related to the obligation of member states to accept and carry out decision of the Security Council under Article 25 that cites that the member of the United Nations agree to accept and carry out the decision of the Security Council in accordance with the present charter. And in that matter, we could analyze things related to decisions referring to Article 25, discussion related to Article 25, and also looking at the seventh case in all the whole report related to the situation in the Middle East. Moreover, a ninth case will lead us to speak about non-proliferation, to refresh that during the year 2020, the status of the Joint Comprehensive Plan of Action, the JCPOA, was discussed by Council members at various meetings and video conferences in connection with the item entitled non-proliferation, and go furthermore to analyze this context of action. That will lead us to check communications submitted in connection with the Joint Comprehensive Plan of Action in 2020, analyze the communication records, the communication titles, and how it was as an explicit reference to Article 25 of the Charter. Finally, the third section of the report will lead us to speak furthermore regarding the responsibility of the Security Council to formulate plans to regulate statements under Article 26. Article 26 gets back in order to promote the establishment and maintenance of international peace and security with the least diversion for armaments of the world's human and economic resources. The Security Council shall be responsible for formulating, with the assistance of the Military Staff Committee referred to in Article 47, plans to be submitted to the members of the United Nations for the establishment of a system for the regulation of armaments. And that will of course lead to analyze a lot of subtopics related to the matter of Article 26 of the Charter of the United Nations and for the Security Council responsibilities in this framework. Moving now to the second topic of my video related to a synthesis of Take Against Terrorism reports. Terrorist use of E2EE in terms of state of play, misconceptions, and mitigation strategies. And in order to analyze this, we have to look at the background, that this will include state of play, misconceptions, and mitigation strategies, and provide a comprehensive overview of the risk and mitigation strategies related to the abuse of services offering end-to-end encryptions E2EE by terrorists and violent extremists. So the key finding from the report starts with user concerns over online privacy and misuses of data that have driven an increase in the E2EE offering by online communications provider, in particular messaging services. As a result, most leading messaging services now offer E2EE as a default or opt-in. Privacy has become a competitive advantage for tech companies who have incorporated the privacy argument into their branding and public-facing communication. Messaging services represent the second most common online activity, with users increasingly favoring private messaging services to social media. Another point, despite user demand for E2EE, policymakers and law enforcement agencies have made calls to rein in E2EE use, often motivated by concern over criminal exploitation of E2EE technology. For example, governments have called for the introduction of so-called backdoors to counter terrorist use of E2EE and have asked that companies monitor their platforms to detect basically issues such as child sexual abuse material. Encryption experts, digital rights advocates, and tech companies all agree that there is no safe backdoor to encryption. Instead, any backdoor would create more security risks, including for individual users, than it would solve. Any friction in the message transmission chain or security vulnerabilities in the encryption protocol risks being exploited by adversarial state or non-state actors. Backdoors to and monitoring of encrypted communication raise significant jurisdictional questions and present a significant infringement of the fundamental rights to privacy. There is also questions related to legal requirements for backdoors or monitoring that will set a dangerous precedent for online privacy. Also, contrary to the rationale underpinning policymakers' calls for backdoors, E2EE is not in and of itself a crucial feature for terrorists when deciding to establish themselves on an app or platform. Terrorists assess several features of platforms before deciding to establish a presence, including usability, stability, security, and audience reach. Last but not least, to counter criminal use of E2EE, we need to go beyond the encryption debate, which juxtaposes a misperception of E2EE features and causing or leading to criminal and or terrorist activity. On one side, against heavy-handed intervention that risk harming security protocols and the right to privacy on the other. Instead, countering criminal use of E2EE should be done alongside the safeguarding and strengthening of online security protocols. Further, law enforcement should consider innovative online investigation techniques to adapt to the digital space. Human intelligence HUMINT and open source intelligence OSINT techniques can be combined for this purpose. Tech platform can on their part explore metadata analysis, network analysis, and link analysis as privacy complaint solution for detecting criminal actors using E2EE services. So the Tech Against Terrorism strongly warned against the introduction of the tools proposed by policymakers in order to moderate encrypted content reviewed in the context of action of the report summarized herein. It includes basically the homomorphic encryptions, also permitting for analysis of encrypted content. Homomorphic encryption still allows to do systematic screening of user contents, which contradicts the privacy promise of E2EE. It is recommended to ensure that any proposal regarding countering abuse of E2EE communications are anchored in the rule of law, do not violate fundamental freedoms, provide clear guidelines for any legal requirements imposed on tech companies. Ensuring also the appropriate redress mechanism exists for individuals whose rights have been compromised as a result of government monitoring efforts. Clarifying what evidence exists in E2EE significantly impeding the work of law enforcement with regards to counterterrorism investigations. Publish regular transparency reports on removal, user information preservation, and other requests issued by governments and law enforcement entitled to tech companies in line with Tech Against Terrorism guideline on transparency reported on online counterterrorism efforts for governments is also the fourth recommendation in order to get onto this framework. So when it comes to publicly commit to end-to-end encryption, very important to analyze that increased knowledge sharing and public communication around the benefits of encryption and about the inherent risks of backdoors to and systematic monitoring of encrypted channels content. With regards to risk, particular focus should be placed on impact on users' rights to privacy and freedom of expression, security risks for all users, including exploitation of these risks by criminals, terrorists, and adversarial state actors, questions relating to the scope of application, the risks associated with vague terminology used in legislation, and related risks for increased surveillance of private communications in the future, risks of mass surveillance of user communication. Then there is the brainstorming related to the emphasis that there is no guarantee that backdoors or systematic monitoring of encrypted content will be efficient in countering and disrupting criminal activities, including by highlighting the lack of substantial evidence that prevented access to encrypted communication significantly hinders the works of law enforcement, or that monitoring of criminal actors cannot be done in another manner. The risk of threat actors' migration to non-cooperative platforms and increased usage of other encryption tools. The fact that E2EE is not in and of itself a decisive factor for terrorists when establishing themselves on an app, especially if the service is used for strategic and propaganda as opposed to operational purposes. Then there is the analysis of the increased public communication about how E2EE constitutes the backbone of today's security and privacy online and offline. The work towards improving public understanding of how their messaging service is designed to protect both privacy and security, with a clear distinction between features working to safeguard privacy and features designed to ensure security. Mitigating risks of terrorist and violent extremist exploitation of E2EE will lead us to speak about designing and implementation of an explicit zero-tolerance policy for criminal actors, especially terrorists and violent extremists, developing an implementation of risk mitigation strategies to counter criminal use of their E2EE messaging services, and conducting risk assessments on how specific features, including audience reach, usability, stability, and security, could cause increased use by terrorists and violent extremists, and develop proportionate countermeasures. There is also the fact of exploring use of metadata to conduct behavioral analysis and detect criminal use of their services in line with relevant e-privacy regulations, and developing or supporting the development of keywords analysis to identify terrorist networks on encrypted messaging services, finally ensuring that user reporting is easily available to users. The supports innovative investigation techniques could include maintaining and promoting constructive working relationships with law enforcement agencies, and capacity allowing, for that matter, establishing points to contact to facilitate cooperation, developing clear law enforcement guidelines detailing what information can be provided and under which conditions in order to increase transparency and accountability regarding cooperation with law enforcement and government, publishing regular transparent reports on collaboration with and requests from law enforcement and subsequent content moderation decisions in line with the Tech Against Terrorism guidelines on transparency reporting is also part of the support innovative investigation techniques. In order to support efforts to counter terrorist and violent extremist abuses of E2EE, it is recommended that governments and tech companies support public-private collaboration to effectively counter illegal use of E2EE while protecting the right to privacy. Supporting further research on the use of E2EE by terrorists and violent extremists to ensure that countermeasures are proportionate and evidence-based. This includes research on criminal actors' cross-platforms migration. Supporting research on the potential risks created by the implementation of technical tools to monitor screen communications related to illegal content, and supporting research on how metadata can be used to detect illegal use of E2EE services. So the summary of this large report will lead us to think beyond short-term impact, because there is a significant risk of long-term consequences with many of the suggested tools to detect criminal exploitation of E2EE. In particular, there is no guarantee that adversarial actors, state or non-state, will not exploit weakened encryption protocols. The rollout of systematic monitoring of E2EE content or the mandating of backdoors access would also signal the possibility of screening all content shared in private communications, including beyond terrorist and other illegal content. These powers could be used by governments in order to monitor private communications for reasons of surveillance or censorship. Finally, identifying the terrorist actors on E2EE platforms via metadata is an important point In order to conclude this synthesis, metadata or non-consent data consists of outside of the envelope between quotes information such as sender and receiver identifications, IP address, basic subscriber information, date, time, and location data. This is information that service provider can observe through the provisioning of services, including when, how frequently, how long, and with whom users are communicating. It could be from a surveillance perspective, such as from a surveillance perspective as well, case by case. This data, especially in bulk, may give insight into individual and collective behavior and social network analysis. That includes the big topic of social engineering. Metadata can be used to inform law enforcement investigations or platform contents moderation without breaking the encryption protection of the communication. However, not all of EE2EE services collect metadata, and while metadata does not contain private communications, it still falls under the protection of the fundamental right to privacy. Moving to the topic of the pandemic, to deplore the fact that COVID-19 is surpassing in history the Cocolizzi pandemic and the Antonine plague. Besides its characteristic of being a worldwide pandemic like the Spanish influenza and the bubonic plague were, at the contrary of the bubonic plague, that is the same proportion of gravity, the numbers of COVID-19 reflects 2 years instead of a century. We already stated the factors contributing to this spread, the variants, the non-asymmetric assistance throughout the globe. The COVID-19 war already marks history forever, as well as the challenging future of mankind as I invoked. It could become the fourth most deadliest pandemic in history, behind third the Spanish influenza, second the Justinian plagues, and first the Black Plague. Besides being part of the deadliest pandemics in history, the pandemic, as I mentioned before, is the third most disruptive historic event to global human mobility, activity, and economy, after second, the combined event of World War I and the Spanish influenza, and first, World War II. Indeed, like its predecessor, the COVID-19 has put once again the world at crossroads with shifting powers and balances at a global sphere. In the annex of my synthesis on the matter of the pandemic, I will include the Institute for Health Metrics of the University of Washington State and therefore the Gates Foundation. The approach that was brought by Scott Gottlieb regarding the development of SARS-CoV-2, and finally the point made by Dr. Tom Frieden regarding the consequences of the failure of transferring technology addressed to Pfizer and Moderna, producer of mRNA vaccines. So stay tuned, guys. Very busy schedule. Looking forward next in the morning to the WFUNA Security Council briefing with the President of the Security Council for the month of October from Kenya. Heads up, as Virgil said in the Aeneid, Virgil is a famous Roman scribe, a scrivener. Fortune favors the bold.